his trial, Nixon put together in secret a unit of basically leftovers from the Bay of Pigs invasion, CIA assets that he brought up from Cuba, who were absolutely loyal and would do anything. And he had given them secret orders to incapacitate him totally. That was the verbatim quote. While he was at an anti-war protest in D.C. And he believes that these policies continue. Now, I don't have the level of direct knowledge that he did. He was at a much higher level of government than I did. But these were the concerns. But setting that aside, right, the personal risk, because this is really what the question is about, why did Martin Luther King Jr. Go to prison? Why do these other conscientious objectors go to prison in these contexts? Because it is an effective means for change in their context. Martin Luther King Jr. was able to show his commitment to the cause in a mass protest context. But is this effective for individual causes where you don't have neighbors who are being sort of marched out of their houses or being sort of violated in very visible, very demonstrable, very public ways, right? The problem with doing mass resistance to surveillance is invisible. Surveillance is selectively applied. And therefore it becomes very difficult to do this. Civil disobedience is first and foremost about disobedience. It is important to understand that there are contexts in which you have not just a sort of moral standing to face the system and show its injustice, but you can motivate more people to come forward on that basis. In Martin Luther King's context, he was spending, I think, 14 days in prison, not 14 years in prison. Mandela went to prison, but not voluntarily. Mandela was sold out by the CIA, interestingly enough, was then captured and turned to prison. And this is the context to remember. If you are an activist, if you are trying to promote the progress in society, you have to think about your responsibility to the public. The reason I am not in jail today is not because I'm afraid of prison. I have volunteered to go to prison without a trial for the government. The reason that I am not in prison is the example that it would set for the next whistleblower, the next person sitting behind the desk at NSA, the same person, or the next person sitting behind the desk at CIA, who knows something is wrong, and is thinking, what is going to happen to me if I say something? Now, in the case of Chelsea Manning, who was tortured and imprisoned for 7 years, or the case of a Thomas Drake, where his life was destroyed, he lost his wife, he lost his career, he lost his house. These are chilling, dangerous, damaging things. These actually cut away at the political heart of the United States. We need to have either just examples or positive examples. And if the government is unwilling to provide justice, I think it's up to the public to provide alternative models for positive outcomes.
Thank you so much for explaining your case, and thank you for all of your answers today. You know, we've spent the last few weeks studying concepts like the right to a fair trial, the right to privacy, the right to free expression, the right not to be extradited if you're going to be persecuted abroad. And, you know, your case really brings up all of these interests, and it's been fantastic, I think, for us all to hear your point of view. So thank you so much for joining us today. Thank you. Thanks very much.
All of you, thank you for having me, and stay free.
Thank you. Bye. Thank you.
ahead and work on the back real quick while you get set up. Oh yeah, it's perfectly fine. Yeah. Professor Metz, I'm going to go ahead and hide the projector.
As long as this screen works, I'm a happy camper.
You want me to keep AV locked?
Oh, no, that was great. Fantastic, very exciting, very cool. Thanks. Yeah, that's coming up after the break. In case you wondered what the interesting classes at Columbia Law School contain, you could have been watching a live Q&A with Ed Snowden, but you're taking SecReg instead. Sorry about that. Yeah. I asked if that was from Russia. Is this working? Hello? Hello? No? This one's working. Let's see. Oh, that does work. Can you hear me? Yes? Hello? Yeah? In the back? Nod? Someone? Yes. Great. Okay. Yeah. So I think nobody knows where he is. All right. How do you follow a mall cleaning? I don't know. All right. She told me she was a securities lawyer back in the day. So see, you too. Who knows? All right. All right. So I thought it would be helpful if we sort of just recapped the law. So I'm going to do that from time to time, and make sure that we're all on the same page as to sort of what the elements are of a 10b-5 action. Actually, before that, let's make sure administratively we've covered all the bases. Office hours tomorrow, 1:15, 1:30-ish, I don't know, just first come, first serve. Last week there was a line, so you can come hang out, get your place in line till about 3. Then I think I have a committee meeting at 3. I think it hasn't been finalized. From 3 to 4, but then I'll be free again at 4. So you can do we can do 4 to 5 or 5:30 or whatever. Let's see. Other administrative matters. We're definitely going to do a review session 2 weeks from today on Tuesday the 24th. 5th? 24th, right? Yeah. And for that review session, we'll discuss insider trading. We'll discuss the hypothetical that I gave you midway through the class, and I'll answer any questions you have. Wednesday, the 25th, there'll be no class. So you can study for exams. What other administrative matters? One of you asked me if I'm going to drop a multiple choice answer that I wrote really poorly, if I wrote the question really poorly and more than X% of you fail it. No, but it's curved, so just don't stress. All you need to do is sort of hit the median or above of your classmates, right? So it's all on a curve. You can't fail the whole class. So can you? You know, it's all. I don't have any control over it, right? So just don't worry. It doesn't really matter. When I was a law student, I remember freaking out about this stuff as I transferred to Yale from a school that did have grades, and I remember freaking out, and then I would reassure myself that no, actually, it's really not that big of a deal because it doesn't matter. All that matters is that you're sort of relative to everyone else doing good. So yeah. So what else? Yeah. So there'll be a multiple choice section and the two essay questions as we discussed. Okay. Great. So any administrative questions? I think you all have the readings for this week and next week. Remember Basic and Matrix, which we won't get to today, but probably tomorrow or Thursday. Important cases, good review of materiality in Basic, but keep an eye also on the fraud on the market material. Make sure everyone has that. Okay. So I put up on the screen here Dura. Was Dura in the readings? Looking at me like, no, you don't know what Dura Pharmaceuticals is. Well, that's a good one to reread. I think it's in the case book. I think it's in one of those pages. But all right. So Dura has this nice statement of the law. So Dura is a 2005 case at the Supreme Court. And I'm just going to go down, here we go. In cases, the courts have implied from these statutes and rule referring to 10b-5. What happened? Come back. Here we go. A private damages action, which resembles but is not identical to common law tort actions for deceit and misrepresentation. You remember our discussion of this in Blue Chip Stamps, and we were kind of debating whether, the right common law paradigm for thinking about securities law is contract or property. Turns out the answer is tort, and at least that's what the courts did. And so we read, Congress has imposed statutory requirements on that private action. What is the court referring to here in 15 U.S.C. 78 U4B4? Does anyone know what that is? Well, what is 15 U.S.C. 78 U4? What is this, besides a section of the U.S. Code? Where did this come from? Somebody did the reading back in the day. Where did this come from? Yes. Jeffrey? No.
Jeff, yeah.
Jeff, yeah.
Private Securities Litigation Reform Act.
The PSLRA, right? Designed to curtail the power of plaintiffs' lawyers, initially vetoed by President Clinton, modified and later enacted into law. The PSLRA requires, Dura points us to Section B4. So there's some procedural stuff here on the class action, which we might talk about next week. It's not really that crucial. But if we go to B, we actually get some substantive law, which is what we're focusing on right now. Requirements for securities fraud actions and any private action arising under this chapter in which the plaintiff alleges that the defendant made an untrue statement or omitted a state, What do we need to have, right? Well, A, we need, in 2A, in any private action arising under this chapter, the complaint shall state with respect to each act or omission alleged to violate this chapter, shall, with respect, state with particularity facts giving rise to a strong inference that the defendant acted with the required state of mind. So that means we need to have in the pleadings a claim as to the required state of mind. We're going to come back to what that required state of mind is. We'll skip the exception. And it turns out that the key one isn't just B, but B4. And that's what Dura is citing, right? Loss causation. In any private action arising under this chapter, the plaintiff shall have the burden of proving that the act or omission of the defendant alleged to violate this chapter caused the loss for which the plaintiff seeks to recover damages. All right. So Dura helpfully organizes all this into a series of elements. Don't you love elements, right? So here we go. In cases involving publicly traded securities in purchases or sales in public securities markets, the action's basic elements include A, a material misrepresentation or omission. C, basic. We're going to talk about basic very soon, maybe tomorrow. You know now what materiality is. We had that conversation in Texas Gulf. Turns out the first part of basic is really just an application of Texas Gulf to preliminary merger negotiations. Remember, we talked about this probability and magnitude test in kind of a somewhat open-ended test. But there it is. There's got to be some material misrepresentation or omission. Maybe in part because that test is so open-ended, that's not the end of the story, right? So one way to think about these other requirements is sort of in response to the fact that, as we discussed in the context of Texas Gulf, really anything that moves the market price, you can always say ex post, probably was material, right? Because the reasonable investor would like to know that the stock price changed. And we said the problem with that kind of ex post reasoning is that it doesn't really give any ex ante guides to behavior. We had that conversation, remember, around the problem of investor expectations rearing its head again here, that if investors expect there to be a particular piece of news about a company, then that expectation will have already made its way into the price. And so the problem with ex post analysis is that it's both under and over inclusive, right? It's over inclusive in the sense that it captures cases where they're ex ante, we don't think for some normative reason we want there to be a materiality finding, because it could very well be that something like what the CEO had for lunch, this is just a little review to remind you of our Texas Gulf conversation. It could be that something like what the CEO had for lunch, we think is, even though ex post might lead to a change in the stock price, it's actually not the kind of thing we want companies to be announcing to the market. And remember the dissent in Texas Gulf sort of pushes this point. Do we want to put the company's sort of brain on loudspeaker, right? And this you can do this analysis in the context of the problem that I gave you, where you think about whether every sort of whim and intuition that President Trump has is that material information. If we link that to the value of a firm, all right, we had that conversation. So ex post price movements are over-inclusive for that reason, and they're under-inclusive, right? They're under-inclusive because it could be the case that the stock price has already adjusted to reflect an anticipated disclosure, right? So if the market thinks that the company has bad news, then that price is going to update even before the company announces it. And so there's a problem with relying on ex post price movements, because it might be a very important piece of news, yet already in the price, and so therefore there would be no price change, and thus there would be a problem with determining materiality in that way. All right, so that's just a review of the Texas Gulf dilemma, and as a result, what you're going to see, we're going to talk about statistical methods, event studies, and ways to kind of come up with some sort of materiality threshold that's workable in securities litigation. But at the end of the day, the courts are going to react to this problem by treating materiality as a pretty low threshold, right? So in the context of 10b-5 litigation, it turns out that materiality is not going to be a huge bar, by and large, right? It was in BASIC, but by and large, remember in this rubric, you want to be thinking about whether, in the case of omissions in particular, remember there is no duty of general disclosure. So bear in mind, and this is what happened in BASIC, I'm a little skipping to tomorrow, but remember in BASIC, they were asked about merger negotiations. And the question is, no comment, is that enough, right? And so the answer is yeah. Okay, not because the merger negotiations, the announcement of preliminary merger negotiations would not move the price. Okay, so the reason why an omission concerning merger negotiations fails the materiality test is not because it would have no price impact, but because there's no duty of general disclosure. So keep that in mind, that in this rubric you're also going to think about whether there's a duty of disclosure. But this is all review. This should be sort of easy for you by now. And if not, come talk to me. All right. Because these tests are in the end going to lead to a lot of liability, we're going to see the courts adding on more requirements. So the second one is this scienter requirement, which we touched very briefly on Ernst & Ernst. Essentially, for private class actions, for private civil actions, we're going to need to see some kind of scienter, some kind of wrongful state of mind. Remember that the SEC is empowered administratively to intervene for violations of Rule 10b-5, and in many cases the administrative remedies available to the SEC have lower thresholds, okay? But here we're focusing on the damage claim, the private damage claim, so let's just make sure these elements are clear. That's element 2. 3, there needs to be a standing, right, in connection with the purchase or sale of a security. We saw last week in Blue Chip Stamps that the court is concerned about every potential party who did not purchase or did not sell as getting a claim, a cause of action under 10b-5, because the concern is that you can open up, if you will, liability limitlessly. And we concluded towards the end of our class last week that there's some weird oddities around that, that maybe it does make sense to say existing shareholders were injured by Martoma's non-disclosure, or by, if you will, Elon's non-disclosure, going back to the Martoma case, but for some reason the non-traders get excluded on the standing requirement under 10b-5. All right, that was our conversation last week. Are there any questions on the first 3 elements? Is this clear? Are you all bored out of your minds? Yes, Beer.
Do these elements for a private 10b-5 action also apply to private insider trading suits?
Great, great. So now you took me exactly to where I wanted to go. Perfect question. So we haven't really been very clear about this, and now we're going to. So it turns out, as you know, that insider trading is a violation of Rule 10b-5. It also turns out that cases like, oh, I don't know, BASIC, or cases that involve Texas Gulf, right? Well, no, was Texas Gulf? I guess Texas Gulf was an insider trading case. So we haven't done many fraud on the market claims. You have them in your readings. BASIC was definitely one, Matrix. But it turns out that these cases involve the failure of a corporation to speak, the duty to update, and the duty to correct cases. We said when we discussed Section 11, remember I said if, in fact, it turns out that the issue is not the inadequacy of the disclosure in the registration statement, but rather the failure to disclose after that point, right? Then what we have is a 10b claim under the 34 Act. Remember that conversation? So duty to update, duty to correct, or actually, affirmative claims of affirmative misstatements by companies, these are also violations of Rule 10b-5. They are also violations of Section 10b. The difference is that in the insider trading case, what you have is the failure of the insider formally, right? Remember going back to Katie Roberts and the way the court sort of plugged insider trading into 10b-5 was to say it's the failure to disclose your material non-public information that's in your possession that works the fraud upon your counterparty. Like that was the sort of traditional way to think about it, right? And the misappropriation theory kind of really stretches that, because in the misappropriation theory, the breach of your duty of confidentiality is to the provider of the information, but the fraud is worked upon some third party, to whom you really didn't owe a duty, but by this kind of weird construction in O'Hagan, where we kind of somewhat convoluted, but okay, it works. In the tipping cases, right, it gets even more remote because these tippees basically have not made themselves any promises of confidentiality. The tippers are not trading, but yet we've constructed effectively a breach of a duty owed to someone up the chain and said that is trading on the basis of this information becomes the fraud. So two kinds of fraud, just to recap so it's clear. There's fraud in the disclosure or non-disclosure, the material misrepresentation or omission by a company, right, by a publicly traded firm. In that case, the defrauding party, right, that is who? It's the company, all right? It's the publicly traded firm. That's case one, type 1, right? Type 2 is fraud in the non-disclosure, in the omission, right, of the material non-public information possessed by the insider. In that case, the defrauding party is the insider. Does everyone understand this? Just make sure this is really clear in your minds. So you got two different parties, each of whom is working some kind of fraud in these stories on their counterparties. Now, the problem is, and what the courts are really going to struggle with, as Abir points out, is thinking about how to compute damages in particular, but these last sort of three elements here, this reliance, this economic loss, and this loss causation, are going to be a little thorny to make sense of, in part because each of these scenarios that we're describing is kind of different from the other, right? So there's like a bunch of different specific stories that we've mashed into the rubric of securities fraud, okay? So let's start with, let's just summarize the elements so everyone has this, right? So we have reliance. We're going to start with that now. This is, in fact, transaction causation, okay? And we're going to learn the presumption in BASIC tomorrow that this fraud on the market presumption that gets us out of having to prove transaction causation. But before we get there, in many cases, and in particular in the classical sort of 10b-5 setting, I don't mean the classical theory, I mean the traditional 10b-5 insider trading setting, it turns out that proving transaction causation is non-trivial, and it requires some careful thought as to how exactly causation works. All right, and so we're going to work through the Martoma example in just a minute, but realize that's a big element. And in fact, we have this economic loss. That's probably not hard to prove. But then it turns out that even though you're going to get the fraud on the market presumption in your favor for element 4 here, for this reliance, in comes loss causation to further kind of trim away at your ability to claim damages if, in fact, fraud on the market holds. Okay? So it turns out that while we're going to start with transaction causation, we're going to look at the cases starting with List v. Fashion Park, it turns out that by the time we get to the world where fraud on the market is the tool that we use for company-based securities fraud, at the end of the day, the loss causation requirement is still going to limit your damages pretty substantially. And disentangling these two is conceptually a little tricky, and so we are going to kind of walk through it one step at a time. To start with, let's start with transaction causation reliance. Yes, Abir, does that answer your question?
So
long answer.
Just to clarify, these 6 elements apply for actions against both the company and the insider in both contexts?
Yes,
okay.
Formally, they do. They do, formally. It turns out that in the case of insider trading, we're going to learn about the development of the disgorgement remedy. And it turns out that the disgorgement remedy is going to make your gains here, your recovery, you're going to be capping your recovery at the insider's gains, which is going to sort of limit in large part, the extent to which insider trading insider trading Martoma-like stories will serve as the basis for civil liability. Because if you think about most insider trading cases are brought as criminal prosecutions by and large, there's a disgorgement penalty that the SEC pursues. Remember, you need evidence, right, of the material non-public information being possessed or used by the insider. That evidence is going to lie with the SEC, the Division of Enforcement. It's generally not going to lie with a private plaintiff. And so in the insider trading cases, what you're going to see is the SEC generally bringing a claim. They will pursue a disgorgement remedy automatically as part of that claim, and they'll distribute the profits back from the disgorgement if they can get money via the disgorgement remedy. They'll distribute that back. So it's going to be less crucial to you as a private plaintiff to bring suit against a Martoma. Does that make sense? Yeah.
Just one final follow-up. Since an SEC action is expressly defined, you don't have all these 6 elements. You just have the ones that are there in the statute. So you just
That's right. So we're not going to worry as much when the SEC brings an action about the never-ending scope of civil liability. But remember, what the disgorgement remedy is doing is effectively capping it. So if Martoma made $100 million, that's all you got to work with, assuming you can get his assets. But generally he's a wealthy guy, was hanging out in Florida, so you get his assets, and you distribute them back, sort of just like what happened with Madoff, right? You're going to give the assets back the best you can to investors, but nobody, remember, this is the point when the Elkhorn case we're going to see, nobody is made whole via a disgorgement remedy, right? That's a really key point. Nobody is made whole. Yet there's going to be a cap to liability there because at the end of the day, we'll get there in 5 minutes, but at the end of the day, there's this concern about letting every potential victim of insider trading sue the tipper. Yes, or tippy. Yes, Christian.
Would you mind just going over the 6 elements and quickly saying them?
Well, they're in Dura. You can just copy and paste them, but I'll read them one more time. Material misrepresentation. 1, scient or omission. 2, scienter. 3, in connection with the purchase or sale of a security. That's standing. 4, reliance. It's transaction causation. 5, some kind of actual economic loss. 6, loss causation. But you can also just copy them from Dura. Yes, Davia. Oh, yeah.
Yeah, you outlined 2 types, you said. Would you mind saying them again?
Oh, sure. So we have, material misrepresentations or omissions that are effectively like disclosure or bad disclosure, right, or non-disclosure from the company. So the company says something, this was the claim in BASIC, no, we're not having merger negotiations, or no comment, or no, go ahead and, we don't have any contemplated transactions. That's coming from the company. And so the securities fraud claim in that case is going to be against the company. The insider trading setting is Martoma went out and traded, and he didn't tell you, he didn't announce to the world he was trading on material non-public information, or he didn't announce his information. And so you want to sue Martoma for the profits, right? In both cases, you have a 10b-5 claim. It's just the target is different. But as I was saying to Abir, really, most of the time, most securities litigation, private securities litigation claims are really going to be about the company failing to speak or speaking in a misleading way, because insider trading requires proof of the possession of material non-public information, and that is very hard for private plaintiffs to prove. Right? It's much easier, especially with fraud on the market, which we'll dive into, it's much easier for private plaintiffs to look at stock prices and to say, oh, the stock price didn't change, therefore, the stock price was elevated for too long, and I'm going to sue on the basis of that. But I don't want to get ahead of us. Let's take it one step at a time. Any more questions? Yes. Remind me your name? Natasha. I got you. Yeah. I'm sorry,
the eavesdropper, so like the person that hears you talking can take that information because you, in fact, you get to hear the insider, but you're not necessarily giving that information out.
So eavesdropping.
Like for instance, the case where
Yeah.
somebody else was listening to her conversation.
Well, remember in the Young case, he listened to her conversation, but then they go to a cocktail party, and he tells the broker So the court isn't actually holding there that eavesdropping is enough, right? Just to make this point clear, so nobody is confused about Young. This came up in office hours, so let me make sure this is crystal clear. In Young, the real question was whether or not the duty would run via the marriage to her. But there was kind of a stipulation, an assumption, if you will, not a stipulation, but an assumption that he is not only learning, like she's aware he's in the room. Right, so it's not really an eavesdropping case, kind of formally. The more typical eavesdropping case might be, you're just hanging around Goldman Sachs, and you just hear, like the person's on their the banker's on a cell phone, doesn't even know that you're there, and you hear him talking about an M&A deal. Okay, so you tell me, Natasha, what can you do? Can you trade on that information you overhear? Yeah, like you're just hanging out on 200 West Street, like down in Tribeca, and you hear Battery Park City, and you hear, some banker be like, yeah, Tesla's going down. Can you short Tesla at that point? Yeah, why? Right? You have no duty. Are you a tippy under Dirks?
I don't think so.
Why? Good, good, and exactly right. Dirks tells us we need to have some personal benefit to the tipper, remember? So this is an inadvertent disclosure. Inadvertent disclosures were actually carved out in Martoma, word for word, if you remember in the Martoma decision. But even under the analytical theory in Martoma, why is it that inadvertent tips would not trigger liability? If you're just applying the Martoma test, Natasha? Remember, the Martoma test is that the information must be given with the expectation that the recipient will trade on it.
Right.
So?
In this case, you're not given the information, you're kind of just overhearing it, so there's no expectation that it will be.
Great. That's it, right? If you're overhearing the banker, then you're not being given the information with an expectation of trading on it. In fact, the banker doesn't even know you have the information. So it's sort of the typical, prototypical. Okay, that was a little exam review. Everyone got it. All right, just make sure we're all on the same page. So now we're moving past substantive insider trading law. I don't mean to minimize your question. I just mean to make sure this is clear. That was more review. Now the question is, after you've established that there is, in fact, eavesdropper liability, let's say because there was awareness, like in the Young case, now the question is, who can you sue? And the answer is, well, depends on whether these elements are present, right? And so reliance is going to be a big issue. So what happened in List v. Fashion Park? Who read the case and wants the all-powerful participation points? Like, I have two people who have maximum participation points already. Who else? Who else? Anybody read the case? Yes. Remind me your name?
Nadia.
Nadia. Hi, Nadia.
Hi. Okay, so Fashion Park was a manufacturer and distributor of men's clothing.
Yes.
And they hadn't been doing well for a couple of years. And so the manager of the union warned that he would take employees to a different clothing manufacturer if they settled nearby. And so Fashion Park called a meeting with the directors, and the union manager urged them to close or sell to a prospective buyer or company. And they adopted a resolution to negotiate a sale or a merger. And then Hat Corp was the buyer, but Lerner didn't find out that Hat Corp was the buyer for a month. Lerner was a minority shareholder.
Yeah.
And so the contract was signed in February with the price of $50 per share.
Yeah.
However, in November, they sold a stake for $18.50 per share.
Yeah.
And they bought it at $13 per share. And so he brought a suit for the difference between the $50 per share and the $18 per share, stating that the buyers conspired to buy the stock and sell at a substantial profit and failed to disclose the material facts.
Yeah. Great. Perfect. 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 Perfect, Nadia. Okay. So you got this buyer, right? So he buys the company at $13.50, and he is not happy that he wasn't told that there might be a deal, right? A deal with Hat Corporation. In fact, that the board was contemplating a sale or merger in which he would receive $50. And the claim is what? The claim is that the defendants are conspiring to buy the stock from him at this depressed price so they can sell it. So who exactly, going back to our conversation to Davia's question, Nadia, who is the party doing the defrauding? Is this the company, or is this an individual insider trader, inside trader?
I think they're saying that it's the company that didn't disclose.
So who are the defendants here? So it's a trick question, okay? Because at the beginning of the case, we read, plaintiff brings suit seeking damages of $160,000 from numerous individual partnership and corporate defendants. Well, that's not a fair question, but it's both, okay? The claim is really that it's both. And of course, you see it's the corporation. You said Fashion Park Inc., right? But it's also the individuals who are part of this conspiracy, so to speak. These folks who, defendant, we're told on 703, William P. Green, the partner in H. Hines & Co., who handled the transaction, contacted Lerner and Beaver Associates to ask if they would like to participate in the purchase. After intensive negotiations between plaintiff and Mr. Green, who's a defendant, okay, the sale of the 5,100 shares was consummated. So there is a claim that this individual is purchasing Mr. Lerner's, right? Yeah, Lerner's stock at a depressed price relative to the information that he has in his possession. So it's kind of like both, right? It's kind of like both. So what's the question, Nadia? So what's like the issue in the IRAC rubric that this case raises?
So it's an issue of reliance.
Yeah. Why is there an issue of reliance?
So in the case, the court says that the test of reliance is whether the misrepresentation is a substantial factor determining the course of conduct which results in the recipient's loss. So I guess it's a question of the price difference and whether he would be entitled to that.
Sure, good. So you're analyzing the law, but just tell the story. So why is there a question around reliance here? All right, intuitively, why might you not want to give Mr. Lerner any recovery here? Yes, Isabella.
He sort of told the broker that he wanted to solicit these defendants. It's not like the defendants went looking for somebody to buy from.
Yeah, that's right. Yeah, so he is soliciting them. And so the claim, just to articulate the reliance, the lack of reliance claim, is that he wanted to sell anyway. So if you ever want to claim that there's no causation, just say something would have happened anyway, right? So yeah. So he calls him up. He wants to sell his stock. Are we told why exactly he wanted to sell? Do you know, Isabel? Do you know? Abir, do you know?
Yeah, I think it predetermined bonds.
Yeah. Yeah, exactly. So he bought it in January of 1959, and then on November 11th, he makes this call to his broker, and he's blissfully unaware that on November 4th, there was this board of directors resolution. But the point is, look, man, you just kind of like woke up on November 11th, decided that you were done, you wanted cash. You are a noise trader, right? You just want liquidity. So you're just going to sell. You have a price. You're actually better than a noise trader, because noise traders, they don't care. They just trade either way. But you actually did pretty good. You bought at $13.50. You're going to sell at least $18, he tells the broker, and it turns out $18.50. Great, good for you. What does that have to do with the court, with the board of directors deciding to sell the company? Like, one has nothing to do with the other, is the claim. You would have sold anyway. Yeah, you would have made more money if you had hung around, but, you know, that's always true. I mean, there could be, you know, I don't know, the Chinese satellite could fall tomorrow and we could all be dead. But it doesn't, like, you know, it doesn't matter. I mean, if something bad happens, something bad happens. If something good happens, something good happens. Those are the risks you take when you buy the security. Notice, I want you to see something here. The reliance element can be phrased in terms of investor expectations. Okay, so see how expectations kind of like show up everywhere. So this is the question, right? This is like theoretically the question, analytically the question. When Mr. Lerner buys the stock, is he buying, well, let me put it differently. When he sells the stock, when he decides to sell the stock, is he deciding to sell having expected that there might be some unknown corporate event that could increase the value of his shares, or is his expectation that there's no such corporate event? Does everyone see that? The answer to this expectations question kind of really determines the reliance analysis theoretically, right? So theoretically, like, before we get to the actual sort of legal doctrine here, just kind of think about it for a second. His hypothetical behavior, if he had known about the sale of the company at $50 a share, like you say, well, everyone ex post, if they had known that they could make $50, would have waited. So the ex post test, like we saw earlier in materiality, the ex post test is really unconvincing. Of course, court doesn't even adopt that here, but I just want you to follow the logic. If you were to say to me, well, after, you know, if the question is, would Mr. Lerner, if he had known about the $50 not have sold, $50 offer not had sold, the answer is yes. He would not have sold with 100% certainty. Does everyone see that? If there's any confusion here, raise your hand. So ex post, yes, he will have always not sold. Therefore, there will always be reliance. The question is ex ante, meaning what are his expectations at the moment he decides to sell the share? This is the theoretical, the economic question. And the answer is we have no idea. We don't know if when he took the price of $18.50, he was saying there's a 5% chance that I'll get cashed out at $50 a share, and that 5% chance, so whatever number you want to throw on there, that I'll make $50 a share, got baked into his willingness to sell at $18.50. Does everyone see that? You have a number, $18.50. The problem is you don't know what goes into that number. I'm not going to work it out because you're all tired of numbers, but just imagine that there's some weighted average here behind $18.50. Right? It could be that, you know, $18.50 is 1% chance of making $100 a share, and that contributes like $1 to the weighted average, and a 99% chance, okay? And you could just average those and get a number at $18.50. The problem is we don't know what those expectations were. We don't know if at the moment he took that offer, he expected that there could be, he took the risk that there could be a $50 a bid coming down the line. So, in light of that, how should we think? Well, what does the court say? Nadia or Isabella, one of you? Anyone?
The court says
what is the test?
The court says that the proper test is whether the plaintiff would have been influenced to act differently if the defendant had disclosed the undisclosed fact. So it's a requirement of causation in fact.
So so how does that fit into this framework? So I don't know, it sounds a lot to me like an ex post test, right? I mean, if you had known that you could have made $50, you definitely would have waited. Well, that's not exactly what the court says, right? So look at 707. What does the trial court conclude? Nadia?
The trial court concluded that he would have sold his stock regardless.
If what? If he had known what?
that the prospect of the sale, the court said that it was too remote at the time.
Yeah. So, but on 707, the trial court concluded that plaintiff would have sold his stock even if he had known that defendant Lerner, an insider, was one of the buyers. That's what the court focuses on here, right? The trial court based this result. So you're not wrong, because we're going to get to the materiality conversation around how serious this was. But just focus here for a second. The trial court based this result upon its findings that plaintiff is an experienced and successful investor in securities. He actively solicited the sale to defendants. That was Isabella's point. His broker knew two directors were bidding, didn't think it necessary to inform plaintiff, and thus the trial court inferred that the plaintiff was so desirous of the potential $5 profit, 5-point profit he would make, and so reliant on his own knowledge that the identity of the buyer would have been little to no concern. So what is the court doing here? Right. So the court is making a decision about expectations, but how is it? Who sees like the move the court is making, the trial court's making? I think it's embraced on the appeal. Yes, Kate?
Yeah, it looks like they're not just looking at this particular plaintiff, but they're also finding the legal requirement of order reasonable investors to see.
Okay. Okay, that's right. But what is the reasonable investor, Elliot? What is yeah?
I think that the court is also influenced by the fact that Lerner then sold his shares $1 later. So they're kind of looking at ex post and saying, well, Lerner wasn't even positive that this transaction was going to go through. So how could the defendant be positive as well? So they're kind of like doing that weighted average test ex post.
Yeah, kind of, right? Exactly, right. So that's in the next paragraph we haven't read. Later, and this was Nadia's point, and that's right, that there's some unidentified person. He then disposed all or part of an interest at an average profit of only $1 per share, so it kind of looks like he was motivated by liquidity. But notice that there's this expectations idea is kind of slipping in here, as Elliot points out. And this relates to what Kate is saying about sort of whether the court is looking at what he knew subjectively. It does seem like they are, except that there's this sort of switch midstream where it's not viewed as a factual evidentiary question about whether I, would have hung on to the share if I knew the ultimate outcome, but rather if the language is phrased as if I knew I was trading with an insider, and then the court makes the move that says, look, you kind of knew that whatever could happen on the merger front was speculative, and so that was sort of baked into your decision making. So while it looks ex post in a sense, there's this ex post language, actually it's really ex ante, because the court is saying, you kind of took this into account, and this is Kate's point, the last sentence here. The trial court presumably inferred from these facts that the prospects for a sale of Fashion Park and for a sale at a price profitable to shareholders, insofar as Lerner and the other defendants apprehended them to be at the time they purchased plaintiff's stock, were too remote to have influenced the conduct of a reasonable investor. In other words, we're going to use the term of the reasonable investor to kind of take that terminology and use that to bake in expectations. We're going to say that, in fact, any investor should be discounting, that is, taking into account the possibility of a merger when they are willing to sell their shares at a particular price. Another way to see this is the court doesn't want to turn the defendant into an insurer ex post. So if the seller, the plaintiff, thinks that there's a 5% chance a merger is likely, even if the defendant knows that those odds are higher, the court doesn't want to turn the defendant into an insurance company for the plaintiff where the effectively ensuring the difference between the ex post realization, right? So there was or wasn't an offer, and what the plaintiff was willing to pay based on that guess, based on that expectation. Does everyone see that? So there is actually an embrace here of an ex ante expectations, and the court is just deciding what they should be, and the answer is they should be these. That is, you should assume, bottom line, whenever you sell a share of stock in this situation, that you might be selling and losing out on a merger. And that should be baked into the price you're willing to sell at. Okay, does everyone see this? That's the actual analysis, right? The actual economics of it. That then gets read in to a causation requirement, right? Because the conclusion is that because you were willing to sell at a price that baked in the probability of this event happening, it must therefore be the case that causation, in fact, is not present. All right, everyone sees this. Okay, next we have affiliated UTI, I don't know. And in UTI citizens, right, we have this little snow case, but we see it come back up. This was a sale. It's a very complicated case, but the bottom line is that the Supreme Court found that in a face-to-face transaction, between a buyer and seller, there was reliance when the evidence seemed to suggest that, in fact, the sellers induced the buyers induced the sellers to sell in the context of a face-to-face negotiation where there was actual evidence as to a conversation where reliance could be established sort of affirmatively in the evidence, right? Because party A is having a dialogue with party B. That leads us to the Frederick v. Bradford case. And what happens here? Well, we don't need to spend too much time on the facts, but I do want someone to tell us what the point of the Frederick v. Bradford case is. Facts are not crucial here. We get them very quickly. Yes? Lauren? No. Yeah. Bernice? Yeah, Lauren. Yeah.
So the point of this one was that the plaintiffs were
Yep.
stock during the time between the 10b-5 violation trade and the public disclosure.
Yep.
So they were trying to, even though they didn't buy from the person who committed the violation, they were trying to get damages from a private suit saying that they were harmed by this trade.
Great. Exactly. So Mr. Bradford here, Mr. Bradford buys the stock on inside information he gets from his dad, and he has to disgorge as a result of the consent decree that's entered into with the SEC. And let me just say, I think I said earlier that all insider trading is criminal. If I did, let me characterize it. The SEC brings a lot of civil actions under 10b-5 as well. This is one of them. And they're often, if you can't establish the requisite state of mind for criminal liability, you can nonetheless get them under 10b-5 because the SEC is not subject to that scienter requirement. So here we've got a consent decree between the commission and Bradford Jr., and he has to disgorge the $13,000 profit. But how much does he owe, Lauren, how much does he owe the plaintiffs according to the district court? No, by the district, before the appeal. It's on the first page. $361,000. Yeah, a lot of money. So like a lot more, like on the order of, 20 times. And the point that the court makes, look, as you said, Lauren, plaintiffs never sold their stock to Mr. Bradford. They didn't even sell on the same day or in the same month in which he bought. But how is it, Lauren, that they nonetheless got a judgment in their favor How did the district court justify imposing that liability? It's sort of on page 311 of the reader. Or anyone else? You got it?
Yeah, they said that the measure of damages was the difference between the price each plaintiff received for his shares sold during the period of non-disclosure manipulation and the highest value reached by the stock within a reasonable time after the
All right, so now it's helpful to open the spreadsheet so we all can just kind of work through this. If you have it on your laptops, you can just open it yourself as well. So let's find that under announcements. Elon stock price. Now we have working AV. So here, one thing you got to do is kind of flip the direction. This is the Martoma case. And flip the direction to translate the Friedrich case to Martoma. Because here, he's buying before the stock increases in value, whereas Mr. Martoma is selling before the stock drops in value. Everyone gets that? So you're just going to kind of mirror image, flip everything around in your mind. All right? So here we have a bunch of plaintiffs who claim that they, sold during the period of non-disclosure, meaning that they, if they had waited, would have sold for a higher price. That's in the case, in the Friedrich case. In the Martoma case, you have a bunch of investors who bought, as we said in class, at these inflated prices. Let me zoom in so we all can see this. There we go. So they're buying, where'd it go? Okay. They're buying at prices like, come on, dates, here we go. They're buying at prices like $34, $35, $33, $32, $33, when the true value of the firm is of Elon here is something like $9 to $11 if you go by the prices in the beginning of August, or if you go on by the price the day after Dr. Gilman gives his speech, it's $19. In other words, the plaintiffs in this case are like equivalent to those who bought in the Martoma case in this window. And remember, the computation we did here was roughly figuring out how many shares were bought during that time. Just to remind you, last week we took the total volume and have roughly cut it in half, which is sort of based on this assumption that it's reasonable that roughly half of the order flow should be a buy. Otherwise, if more than half were a buy, the price would be rising. If more than half were a sell, the price would be falling. But because the price is relatively stable over this window, the 21st to the 29th, we can kind of roughly say it's something on the order of 50-50. And so we computed how many shares were bought during this window. And we said that these folks who bought at 33 or whatever are mad. They're hurt. They're injured because the stock price fell. Now, where is Sam? Is he not here? No, he's not here. Sam pointed out that there's also a group who should be very happy because they sold, in fact, the same number. In fact, probably exactly the same from a social welfare standpoint. These two cancel out. But we're not talking about social welfare, right? We're talking about these injured investors who want to bring a claim under 10b-5 for the transactions that were executed at the wrong price. In the Martoma case, it would be those who bought during this window. Here, it's those who sold during an analogous window where the insider is making money. All right. So, Lauren, what does the court decide about folks like these?
So the court says that people like this don't have a civil claim from the defendants.
Yeah. Why?
So the Sixth Circuit here is trying to rein in what they call draconian liability. And they found that the plaintiffs weren't actually influenced by the defendant's actions. They
Yeah,
doing their action.
exactly. So Lauren makes this great claim that seems to be very persuasive to our judiciary, which is that, you know, if you were going to trade anyway, then there's no causation. So the fact that by accident, well, it's not really by accident because the insider did trade. But the fact that you traded at the wrong price, wow, that could just loop in everyone. In fact, we calculated it's something on the order of 1.2 billion in damages potentially. You just see that here in the Excel sheet. You know, 1.3 billion, 1.2, I don't know. What, this is the wrong number, right? Because it's, yeah, that was the opening price. Anyway, it's 11.3, 1.2 billion. It's like 1.2 billion in losses. So that's massive liability. And there's this point that the concurring judge makes. What was his name? Celebrezzi? It was Calabrese for me. No, it's Celebrezzi. Celebrezzi? Okay. He makes this point that, that actually what that would do is turn the defendant into an insurer, which it would, right? So if you know, sold during that window and the price went up, you get compensated, you would get compensated for the difference. Similarly here, in the Martoma case, if you bought during this window when Martoma was trading and the stock went down, you would get insured by the defendant effectively for that difference. The court doesn't like this. Now, what I want you to think about, and I hinted at this last class, is that there's a little bit of a puzzle. And you should probably already see it. Does anyone, I'm going to see if you can guess why this analysis kind of has some weird logic to it. Remember, just to give you a hint, how I explained how prices change in markets and the effect of insider trading on prices. What's wrong with the entire conversation so far? There's like something very fundamental that's wrong here. Does anyone see it? Abir, do you see it?
The price reflects the damage caused.
The price reflects the difference in value. Yeah, so it's really low on August 1st, which is bad. So that's a loss. There's something about the causation conversation in this case in particular that's really strange. If you think about the economics. Christian?
I'm going to go out on a limb, but does that have to do with the thing about information being revealing and it being an anonymous market?
Close. Not about the anonymity part. Something to do with information, always in this class. Yes?
Is that, in this case, the inside trader is actually increasing price accuracy by making the trades?
Yeah, Paul's on the right. Yeah, Paul's on the right direction. Very close to the exact point. So can you just articulate that more?
It's not causing the losses, it's actually preventing the losses.
Right. So let's take it to the logical conclusion. Suppose Martoma went nuts and started shorting this company the moment, like 5 times the shorting, the moment he hung out with Dr. Gilman, like somewhere around here, right? When does he start trading? On the 21st? Say he just like shorts the stock really, really fast, like just dumps all of his options. What do we say is going to happen to the price? Or buys a bunch of put options. I don't know. What's going to happen to the price? You guys should know this now. Elliot. Yes. This is going to be on the exam, guys. Okay? I've been like nice, but I want to make sure you really, nobody comes to me in 4 weeks and says, why didn't you tell me this was going to be on the exam? This analysis is going to be on the exam. Okay? So make sure you get this. So say more, Elliot?
Well, if Martoma would dump all the file put options, the price
Right?
would go down immediately.
Right? What happens to this 1.2 billion?
And that would shrink.
Right.
People would be injured by the trading.
A lot less. Right. Now, we're going to make a little bit of an assumption that it's not a one-for-one swap. Okay? So it's got to be, you know, the case that you don't have 1.2 billion on that day, but that would never happen. and I mentioned this last time, I sort of hinted at this kind of nonlinearity, right, or non-additivity in the sense that Martoma could accelerate his trading, and because that sends such a clear signal of negative information, the price will fall very quickly if there's enough volume behind that. And it's actually going to be hard for Martoma to execute trades. This is the key point. Remember, we talked about the Kyle model. Okay, make sure you know this. Remember, I said, think about, the insider strategically doesn't want to trade too fast. Because if they trade really, really fast, that price is going to fall too quickly. And they're not going to make money on their trades because the insider's profit turns on that price not falling too fast. So it's actually Martoma's non-trading that causes all of these transactions to execute at the wrong price. Very important. Very important. Are there questions on this? I really want to make sure you see this. Yes, Davia.
Was that, I guess, a part of what? I'm sorry, I'm blanking on his name. Threat. Okay. In the Philip Martoma's case, the.
Katzman?
No, the guy. Right?
The guy. Help me here. Okay.
Sorry.
Gilman?
No.
The doctor?
No.
Okay. I'm figuring it out. Okay. Preet, Bahara. There we go. Preet. He has a radio show now, iTunes, podcast. Okay. Yeah.
The question that I have is that you're saying that essentially because Martoma decided not to trade on this, it caused all these, these trades to occur at the wrong price. Now,
Right.
previously said that Bahara's idea was that people were harmed because of because he traded essentially the wrong time, if you will, right?
So Bahara wants no trading until the company announces. He wants it to look like a cliff, like a rectangle.
So it's the harm, essentially that Zara Martoma didn't trade.
So let me ask you, is the harm greater or less if it looks like a rectangle compared to what happened in the data? Yeah, what do you think? I'm asking you, but I'm giving you the option to remain silent and thereby allowing others, if you want. It's up to you. Yeah.
Didn't you say that, basically, this could, at any time, this could have changed or whatever?
So, I mean, just think about the number of trade. If the claim is this guy up here, this person up here bought at too high of a price. Well, if they buy up here, they're buying at an even higher price. So more people are buying at too high of a price until the disclosure happens. Right? Price accuracy means trades execute at prices that are better for they're closer to the true value. So the only way, what's the only way, this goes back, where's Joe? This goes back to our conversation last week. What's the only way that you actually help these poor souls for real? Avia, do you know? Anyone see it just in the picture? Joe, yeah?
You just disclosed it earlier.
Yeah, you just got to you got to make the vertical line in here. And just kill okay. So, fine. So we'll argue about what the proper standard of disclosure is. One of the problems in the Martoma case is the company had no duty to disclose. There is no affirmative duty to disclose material information. Remember that. So you have an issue. Okay, you can decide when to announce your material clinical trial results. So that's the law. So unfortunately, Bahara's ideal is that we would do this. I mean, his ideal is that it would look like this, but that's actually the maximal harm because this is unavailable until we change the timing of disclosure rules or something. The short cliff is unavailable, so the long cliff actually maximizes the harm to investors, to buyers. Does everyone see that? Yeah, Magdalena.
In this way of analyzing this problem is that we look at those who invest and the inside traders, but there's a third group I think very important in that we should think think of. And
Yes.
That's why
Who's the third group?
information traders, the analysts, those who,
Say more.
well, either the information, those who spend money to collect information.
Good.
Yeah.
So what about them?
It will be the corporation who has been working and has put the information, but it could be also analysts who are providing the information, the
Right.
informed trader who are not necessarily
Yeah.
working on inside information.
Yeah.
But are,
So these sort of informed listeners we talked about. Right.
and probably this group is essential for.
Yeah. So if you have informed listening, Magdalena makes a great point. If you have remember we talked about competition. We said if you have competition between informed traders, or you can think of informed listeners like analysts as a sort of legal version of martomas. But at the economic theory level, this line should be getting steeper and steeper because they each want to beat each other, effectively creating the short-term cliff, right? The short rectangle here that actually does make everyone better off, but only if they compete on the basis of some sort of informational advantage that yields them a profit. And so, yeah, that actually works without disclosure. This goes back to our tension between informed trading versus disclosure. But I want to stay in reliance because that's the law we're looking at right now. And does anyone understand, because I don't, how exactly the insiders trading here in this case, like in Martoma, in any sense caused the losses of the buyers in this case, or I'm sorry, the sellers in this case, or the buyers in the Martoma case. How is there causation, right? Like, where is the causation? Anyone? Like, I can't see it, but now that I've said that, you probably won't even try. But I mean, someone. So bottom line, we have 4 minutes. I'm just gonna sort of aggressively conjecture that there is none, right? Like theoretically, analytically, there is no causation. Insider trading makes prices more accurate, and like informed trading in general. So therefore, losses driven by inaccurate prices cannot be attributable to the insider trading. So in this way, maybe we agree on the outcome. Okay, these folks can't bring a claim, but not because it would be turning the defendant into an insurer, but because the defendant's trading benefited them, if anything. Now, this intuition is going to be fiercely resisted, okay, by the courts. In the Elkind case, bottom line, we have Tippy trading of 1,800 shares, and the court embraces a disgorgement remedy. Yes, Alistair.
Isn't it the case that the insider trading doesn't benefit, like it might benefit the market, but it's not benefiting the individuals who trade with them? Isn't that the whole basis of the liability?
Yeah, so there's a group of folks who lose to the insider always, but the group of folks who lose, remember, they're non-additive, okay? Like one doesn't substitute for the other fully. So if think about it like this. For every additional gas acceleration that the insider puts on their trades, there is a somewhat larger group of folks who lose because they're trading against an informed trader. But there's an even larger group, and this grows non-linearly, right? So this second group gets bigger and bigger, who benefit because, in fact, the price accuracy goes forward from that point on. So yes, the harm will increase, but the benefits, and we're always sort of looking only at the losing party here, right? Remember, there were a lot of traders in this case as well who bought just by random chance from Mr. Bradford, just like there were a lot of traders who happened to sell by random chance, but we're not adding up the gains and the losses and making any kind of statement about aggregate wins or aggregate welfare, because at the end of the day, these all cancel out. The aggregate welfare from insider trading is basically zero, okay? We're just sort of saying, look, let's look only at the victims. And my point is the class of victims actually shrinks as the price becomes more accurate, and in fact, shrinks more so than the class of victims would enlarge as a result of greater insider trading. That is mathematically true. All right, so we're out of time, but we'll talk for 2 minutes about the disgorgement penalty, which is kind of like the court's sort of attempt to come up with a damage remedy because we feel like it's wrong that the insider has profited and someone has lost, but we really don't have a clear theory of causation. Doesn't really make sense. So what we're going to do is we're just going to give the insider's profits back to the victims. So you get partial insurance, right? You get partial insurance up to the insider's gains. Think for tomorrow about what that does to the incentives. Going back to Magdalena's point, if you are an informed trader or informed listener and you face some degree of competition, you know that you're only going to be able to make a certain amount of profit before the stock price falls quickly. If that profit is disgorged, that means you make zero expected profit under the disgorgement remedy. So your optimal investment in information acquisition is zero. And what's the effect of that? Well, it might look something like this long line until the disclosure, which is, again, the kind of ideal that people like and yet yields the greatest harm, right? At least when you define harm as the half who are harmed. Okay, see you tomorrow.
Hey, Alice. What's up? I just wanted to follow up on the question that I asked. So, when you're talking about insider trading and the number of victims, are you defining, like, victims by the people who buy the stock at an inaccurate price? Because when you're talking about, oh, you'll have a steeper cliff if the insiders trade more aggressively, and that's going to lead to more accurate pricing. It's like, that's true, but the way that the drop-off happens is there are more people trading with the insider, right? So empirically, it seems like there would be more victims, even if in the long term there will be fewer people buying it at a mispriced price.
No, so that's what I mean. It's so define the counterparties to the insider trading. Yeah. Okay. As let's say the losers to the insider, I'll just say LI, and define these as the losers, to the public, right? So it's always the case that for any change in this, right, that the losers to the insiders are always going to be less than losers to the public, right? In other words, find this dollar volume, if you will, total dollar volume, always going to be the case. And the reason is because the price will react non-linearly much faster. So suppose the insider places a more aggressive order and captures another, 1 million in profits from the counterparties, right? Yeah. Well, by capturing 1 million in profits on a single day, you tip off the market maker a lot faster. And so the savings here is not 1 million. It could be on the, it depends on the model, but generally, because of the nonlinearity of it, this will always be greater than 1 million. In fact, it could be substantially greater.
Yeah, so if they do the million at once as opposed to 100,000 a day for 10 days, that'll tip off the market faster, but it's not going to change how many people have lost money by trading with the insider, right?
Yes, it will. Because...
Well, it'll change how many... It's not going to change how much the insider's counterparties have lost. It'll just change...
Oh, yeah, right, exactly. It won't change the... That's right. But it will change the market maker's... Just remember, the way the market maker sets the price is by looking at the order curve, right? Yeah. And this buy, sell, okay? The probabilities here, if you ever think about like a normal distribution, okay? The probability of getting... normal curve. The probability of getting a sequence of sell is very small. The probability of getting one more cell, getting a sequence like this, 8 cells, 9 cells, is way less than the probability of this sequence. Yeah. Which is way less than the probability of this sequence. And so as you add an additional cell order, the chance of there being inside information goes up exponentially. And so the market maker will discount the price heavily at that point. So while you're still executing these trades,
Yeah.
you're executing a much faster decline in the price.
Yeah, and I guess that my question is if the company can be either overvalued or undervalued, and that's an idiosyncratic risk, why do we care about the losses to the public as well, and not just the losses to the people, to the insider trader?
Well, that's a very good question. We shouldn't care, if we think of this as diversifiable, we shouldn't care about either. Because for every insider to whom you're losing,